Did it start? There we go. All right, hello, and welcome to the GRadulting Workshop Series. Today's workshop, we will address the topic of job contracts, and I hope that many of you have lucrative job contracts waiting with your questions. So my name is Debbie McCutsky, and I'm the Coordinator of Services and Programs for Graduate Student Legal Aid. I use she, her pronouns. This workshop is co-sponsored by graduate and undergraduate student legal aid. The legal aid attorneys are here today. Well, at least one of them is here today, Cindy Schilling. Cindy, say hi to everybody.
Hi, everybody. Welcome. I think we have a good mix of graduate and undergraduate students, and everything that these esteemed attorneys will tell you will apply to any job contract that you're looking at. So we welcome undergrads and grads as well. Nice to see everybody.
Exactly. Thanks, Cindy. Zach Mundy is the attorney for graduate legal aid, and he was unable to join us today. But please use Zach and Cindy. They are great resources right here on campus and virtually. So let me just tell you a little bit about legal aid, because in addition to these workshops, we offer legal consultations on general matters like you're having a problem with your landlord. That's something that we deal with a lot. Legal consultations on immigration matters. We have an immigration attorney that meets with students once a month. So if you're an international student and you have some burning questions, we can help you. We provide advocacy for students who are charged by the university with the violation of the Code of Conduct or the Code of Academic Integrity. And Cindy and I are notaries. That is really the only in-person service we're providing now. But we are happy to notarize documents that are either personal or related to academics. So, and I should say, all of our services are free. In fact, you've already paid for them because you've paid your student fee. So we are here. Use us. We want to be busy. We want to be helping you. So before I introduce our speakers, just a few announcements. Automatic closed captioning has been enabled for those who want to read along. We welcome your questions and your comments, so post them in the chat and direct them to everyone so everyone can see your questions. Near the end of the workshop, we will post a link to a survey. We only ask 4 questions. We want to know how we're doing and what ideas you have for future workshops. So please take a minute to respond to that. After the workshop, either later this afternoon or tomorrow morning, we will send an email to everyone who registered. It'll have the links to the slides and as well as to the recording. And if there's any handouts, we'll share all of that. And last but not least, I want everyone to see and say hello to Veronica Perrigan. She is the Assistant Director for Student Services at Engineering Career Services, and some of you may have already met with her, but she suggested that we offer this workshop a few years ago, and we have been doing it, I think, annually since then. And she's done a great job with helping us promote this to the engineering students. So thank you, Veronica. It's great to see you. Okay. I'm almost done talking. Let's get started with job contracts. I am so pleased to introduce our speakers, Joyce Smithy and Lisa Walker. Joyce is a highly respected employment and labor law attorney, and she is the founder of Smithy Law Group, which is located in Annapolis. She represents employers and employees throughout Maryland and the District of Columbia. And she's got 22 years of employment law experience. She brings a wealth of knowledge to helping her clients and to helping us here at the university with our workshop series. She has been helping us with this since 2019. So Welcome, Joyce. I'm so glad you're back. And I also want to introduce your colleague, attorney Lisa Walker. Lisa is a senior associate with Smithy Law Group, and she and Joyce are going to be presenting today. So thank you both, and please take it away.
Thanks so much, Debbie. It's great to be back. We've made it a habit now. It's an annual and sometimes twice annual event. It's it's a lot of fun to get people before they make the mistake with the contract. As a lawyer, I get the after all the time, so it's really fun being here every year. I look forward to it. As Debbie mentioned, I live and breathe employment law. I've done it for 23 years now. I founded a firm solely dedicated to labor and employment in Annapolis. We have 9 attorneys. Lisa's been with us since the inception. She lives and breathes it too. We're both published in employment law. And in fact, I can literally say I wrote the book. It's on my shelf. And our firm was just named the most preeminent labor and employment law firm in the Mid-Atlantic. So if we're really excited about employment contracts, you'll have to understand we've devoted our lives to this stuff. So really the idea here is to walk through, you're going to be handed contracts at some point at the beginning of a relationship when everything is rosy, you can't wait to work for them, they can't wait to have you work for them. And what we want to go through is kind of what you're going to see and what you should look out for. It's easy to say, you know what, nothing will go wrong. For many, that's true. For some, it's not. And if it's not, it can be one of the biggest events of your life. And also, skipping over things. I don't understand it, so I'll just sign it. Hopefully after this, you're going to understand what you're signing and feel a little bit more empowered in the market when you get that great job. Ready for the next slide? All right. What is an employment contract? Pretty self-explanatory for most. Usually it comes in a written format that both you sign and the employer, but in all jurisdictions in the US, an oral agreement is also a contract. You can actually have a handshake deal still that you can sue over in court. So keep that in mind. It just because it isn't written down doesn't mean somebody doesn't come back and say, wait a minute, we had a deal. So it can be written or not. Always better if it's written. You can't have a fight over what somebody said if everybody put it down. You can also have implied contracts, either from things people say. Hey, if you keep working here, I promise to give you a bonus at the end of the year. Okay. And you keep working there. That's an offer and acceptance. It can be implied for handbooks, right? If the handbooks you get in your workplace promise things and it doesn't have disclaimer language, that can be a contract. So we all have the traditional idea in our head of what a contract looks like. We've had signed leases, things like that in our lives, but it can take many forms. Next slide. Covenant of good faith and fair dealing. So within every contract, this covenant is implied. It doesn't have to come right out and say, hey, by the way, let's behave in good faith. Every contract has this covenant implied in it, which means you can sue for a breach of this covenant. And the idea is, if you are a party to a contract, you're agreeing to perform your contractual obligations in good faith, right? So sometimes we get calls from people who are like, well, it's not a technical violation of the contract, but all these other things are going on and they're not giving me the equipment I need to do my job and it's causing all these problems. If you're not being dealt with in good faith, you can have a breach argument just for that. So keep in mind, as you enter these, everybody, you do, your employer has a duty to behave your obligations in good faith and in fairness to the other side. Next slide. So not every employer is going to want a contract. Usually the higher up you go, the more likely they're going to want a contract. When do they want it? If you're going to be an important employee, they want some control over how you leave. Most jurisdictions are at will employment. So if you don't have a contract, you can quit whenever you want. And if you're an important employee, they don't want that. So you'll see it when they want to have some control over when and how you can leave. They need notice to be able to not have an interruption to their business. They may care a lot about some of the clauses we're going to talk about. Lisa's going to talk about clearness on work for hire, or they may want confidentiality obligations in writing. But they are two-way streets, right? If they're going to promise you employment for 3 years, you're promising them that they really, it can cause them to lose flexibility as well. So you don't see it all the time, but when they want it, it's because they want to have a little more control. Again, I named some of the types of jobs where it's going to be likely you get this. If you have access to confidential, sensitive information, trade secrets, they're going to want to protect those secrets, whether it's lists of customers, whether it's inventions and intellectual property. They're gonna have you sign a confidentiality agreement if you have access to that kind of information. Non-competes. These continue to be a very, very busy area of law. This varies state to state. It is not a federal issue, which means wherever you go, your state could have different laws on it. And it ranges from laws that really say, okay, some states say these are fine. California, you're not even allowed to have one, right? So non-competes in Maryland, we still see them all the time. And the idea is they don't want you spending time on their dime and then going and competing against them. That's a reason they do it. Sometimes they use it to win out a bidding war, right? And post-COVID, certain fields are having a hard time hiring employees. So they may use it to lure you there. Hey, we'll give you some security. It also can make termination really easily, right? If they reserve their right in advance to say, we terminate for any reason, or, this happens, it's an automatic termination. This makes it really easy. As I mentioned, usually used for senior managers, higher level employees. I think I saw a question.
You did.
I can read it. Mohammed is asking, what do you mean by jurisdiction? Is it the state, county where you work, or where the company's headquarters is?
Great question. And some of that will depend on what you sign. Lisa's going to cover that. If you don't have a contract, your jurisdiction it's both the country, your jurisdiction is the United States, the state, and even the county. For example, in Maryland, Montgomery County is very active in its own laws to protect employees. So we get clients who have claims and jurisdiction under United States Code, Maryland law, and county code. So if you don't have a contract, it'll be wherever you're performing the work. If you do have a contract, it can be where the contract says, the jurisdiction identified in there. It may say your employment is governed by the laws of California, even when you're working here in Maryland. If that happens, I wouldn't argue. California has a lot of protections for you. So it really depends. If you no contract, where you're doing the work. If you have a contract, it could have a clause saying what jurisdictions apply. Okay, next slide. I touched on this. Do they have to offer a contract? No. There's no law requiring a contract. They don't have to. You can have an entire workforce working without a contract. In fact, the majority of workers do not have one. So there's no obligation. But again, there are times when it makes sense for both sides. And frankly, if you're a strong candidate, sometimes they will offer it as an enticement to get you to sign on. So they don't have to, but it's certainly commonplace for certain types of employees. Next slide. I'm going to turn it over to Lisa now to talk about the clauses you're going to see when you're handed a contract and what they each mean, so that you don't look at it and say this is just legalese, but what do they each mean for you?
Okay, yes. So I'm going to talk a little bit about some of the standard clauses that are in a lot of employment agreements that you'll see, and they may look like legalese, but where it's important to pay attention. So there may be a best efforts clause, there may be a position description, there may be certain duties and responsibilities of your particular position that they want to lay out in the agreement. And a best efforts clause is just going to be letting you know, to pay attention to the fact that you're supposed to be putting your best efforts forward in this particular job. Next slide. And you want to make sure that in your duties and for your duties and responsibilities, if it references another document, that may lay out more duties and responsibilities, make sure you ask for that document. And then next slide, please.
Hold on a second.
We're on 7. if
Thank
can see
you.
that.
I can't see the numbers.
Okay.
So tell me when to stop. Sorry about that.
It should, yep, that's it.
That's it. Thank you.
Yes,
Sorry about
thank you.
that.
No problem. So the compensation is going to be a key term that's probably most people know to pay attention to. It's going to let you know what your salary is for your position, how often you're going to get paid. For instance, in Maryland, you have to pay biweekly at least. So you'll find out, more about bonuses, how those are structured. For instance, it may be a subjective decision from your supervisor, or it may be based on metrics. You want to find out in advance how those are calculated, because we've had several clients where it wasn't laid out very clearly, and both the employer and the employee had different memories of their conversations early on about how to calculate that bonus. And then whenever the employment ends, they're expecting these large bonuses and they don't get them. And if it's not in writing, it's very difficult to recover. You may have a profit sharing option. You want to pay attention to how long you have to be at the company before your shares of stock are vested, meaning whether if you leave at that point, those shares of stock are yours. Same thing with stock options. And it may have things like expense reimbursement. If you were to go to a conference or a meeting, how those expenses are reimbursed, whether it's, how long it takes to get those reimbursements. If you are in sales in particular, a company car may be offered, or, they may offer an allowance for a vehicle. And so you want to pay attention to how those are paid, how long it takes to get reimbursed for those kinds of things. Same thing with moving expenses. You want to know if you're getting, if there's a limitation on it, if you're getting it up front, or if you're, getting reimbursed and it's going to take a while before you get reimbursed. Next slide.
Lisa, I don't know if
Yes,
you want to
ma'am.
take these questions now or table them,
Sure.
but Aria has asked, is it legal to ask the employee to do jobs that are not listed in the job description? And then Sina has asked, what do you mean by stock options?
So is it legal for the employer to ask? I would say in most cases, yes. If it's not in your agreement, if, for instance, when we get to the termination for cause and all of that, it may become relevant whether or not it was in the contract in the first place. And if you weren't performing a particular duty that wasn't listed in your contract, it might be harder for the employer to terminate you based on not performing that duty. So generally, yes, it's, they can't necessarily treat you differently than other employees if, based on illegal reasons, but generally they can. And for stock options and profit sharing, you may have the option to, for the company to pay you, part of your compensation will be in profit sharing and stock options. And that generally encourages employees to work hard on behalf of the company, because the more successful the company is, the more your stocks will be worth. But there may be a clause in your agreement that says you have to be at the company for 3 years before these number of shares will vest, meaning become yours. And so whether you leave the company or you stay at the company, if you left the company, you could sell those shares of stock back to the company. Or there may be other terms for you to pay attention to for, whether or not you can keep them when you leave and so forth. So It's profit sharing, and stock options would be owning shares of stock in that particular company, the employer. Are we ready for the next slide? So I think we might have skipped the one before. I might have confused you. Yes. So another thing that you're going to normally know to pay attention to are, you know, the benefits like health plans, how much you have to contribute to a health plan, how much the employer is going to contribute. You want to make sure that if it references those benefits in your employment contract, that you get the full plan documents, not just the summary page or what's in the handbook. Employers usually have the right to change those benefits, so you have to pay attention continually during your employment. And then you could receive this in a employee handbook too, but if it's listed in your agreement in writing, whether or not you're going to be paid your vacation leave that you've accrued while you're there, that's what's going to govern. You know, for instance, in Maryland, you have to receive in writing the terms of if they're not going to pay out your vacation leave upon termination, they have to let you know in writing in Maryland, but not every state is like that. So whatever state you're in or whatever state governs the contract, you should pay attention to. Next slide. So different employment contracts are going to have different durations, and it could be a 2-year contract that renews every 2 years, or it could be an indefinite contract and it just terminates upon notice from one party or the other, or on a particular event. So you want to pay attention to how long the contract is for, especially if there's an automatic renewal term, which might automatically renew your contract for 2 more years. And then it might be it might be disadvantageous to you to leave if you're not paying attention to the period where you need to renew and your contract renews, but you're thinking about taking another job 6 months later. That could be an issue. So you definitely want to pay attention to how long the contract is and how it renews, and when it expires. Next slide. So there may be a clause in your agreement that lets you know you have no authority to bind the company, no authority to contract on behalf of the company. So there's something in agency law called apparent authority. And if you've given the impression to another, like a vendor or another company, that you have the authority to bind the company, they may be liable for something that you've signed, even though you don't have authority to contract. So if they've let you know in your agreement that you don't have authority to contract on behalf of the employer, you could end up being liable for whatever the company is out because of you entering a contract when you didn't have authority to do so. So that's just a clause you might see. Next slide. So a lot of, especially when you have a position where they're wanting you to sign an employment agreement, you might be limited to only working for that employer. That's, you know, to have your focus exclusively on that job and to keep you from working for a competing firm or something like that while you're working for them. So if you're thinking about having a business of your own on the side, sometimes it may prevent you from owning shares of stock in another competing business. Those are things you want to make sure are dealt with in an agreement. And if you have an exclusive employment clause in your agreement, that might prevent you from having that business on the side, or owning a significant amount of shares in another competing company. Next slide. I get this question a lot, even just from my friends and family. Almost every state is an at-will state. It's not just Maryland, or you know, a lot of people are just familiar with the state that they're in, and they'll say that Maryland is an at-will state, but most jurisdictions are. And what it means is that the employer can terminate you for any reason that's not illegal, and you can quit for any reason that you want. They can't make you work for them, although there may be consequences for, you know, leaving a contract early. But an at-will agreement will basically just state that either side has the ability to terminate the employment relationship. So a lot of times this is something that you'll see in a handbook, maybe on an acknowledgement page, that just states your employment is at will, and that, you know, the manual in no way contracts, you know, it removes that principle governing the relationship. And you'll generally, there's not, if the employer terminates you, it's generally not illegal, even if you don't like the reason, even if you don't think the reason is a good one. Generally, in an at-will relationship, the employer can terminate you as long as it's not in violation of a law like Title VII or FMLA. You know, you can't retaliate for someone using FMLA or things like that. So generally, the employer can terminate you for any reason that they want, as long as it's not illegal. Next slide. The termination for cause and without cause, I found if you have a detailed clause like this in your employment contract, is one of the most complicated portions of an employment agreement, because the employer will want to include a very general term in their reasons that they can terminate you for cause. And that means that you leave the employer in a less beneficial way than if they terminated you without cause. So there may be, for instance, a provision under a clause like this that says you can be terminated for failing to carry out the duties that are listed in another section of this employment agreement. And the duties that are listed might be, you know, putting your best effort into this or this. And it's a very subjective description of what your, you know, what expectations you'll be held to. But usually there's going to be some description of for cause terminations. It could also be for breaching the agreement. Again, there may be a section on duties and responsibilities, and they may say that you've breached that, you know, portion of the agreement. If you have a clause like this, it's really important to get clear terms on what is termination for cause. Without cause would be like if you're laid off, you know, because they eliminated the position, or for some other reason that doesn't have to do with the fault of the employee. So, and another provision that might be under this section might be resignation for cause or resignation without cause, and you may have similar advantages and disadvantages to ending the employment based on that. There may be a notice provision under a for cause termination provision. You definitely want to negotiate that if there is a for cause provision, which basically says the employer has to give you 30 days notice or some period of notice, stating, you know, why they are going to terminate you if you don't fix this issue. It's called an opportunity to cure. So that's a clause that's really important that you want to pay attention to. Next slide. So similar to the for-cause, or related to the for-cause clauses, a severance provision might limit or provide a severance package upon termination of employment. So it may say if the employer terminates you without cause, for instance, eliminating your position, you're entitled to this period of severance pay. And that's really important. And it's another reason why the for-cause provisions are really important, because the employer generally wants to argue that they're terminating you for cause. The employee wants to say, no, you're terminating me for some reason that's not in the employment agreement, and so you owe me severance. And so we have clients who come to us for that very reason, and we're arguing, sometimes over very vague terms that were, they came to us with a pre-existing contract, and it's hard and it can be difficult to overcome a very subjective clause about what, why they can terminate you. Unprofessional conduct is one that is often used by the employer to say they acted unprofessionally when they raised their voice, at a supervisor, or left early one day or something like that. So in a severance provision, you may have, different standards of the length of time that you will get paid, usually in conjunction with how many years you've been at the company. So you may get, 1 month per year would be a decent, severance package. So if you were at the company for 12 years, you might get 12 months of severance pay upon termination without cause. Next slide. This, especially if you're in an engineering profession and other sales professions too, trade secrets are going to be something that most employment agreements are going to have a trade secrets protection clause. And that is going to include things like client lists, methods of doing business, and terms that are in contracts with clients, price lists that they don't want out, a lot of proprietary information that the business feels should be kept confidential to prevent other businesses in a similar field from capitalizing from their property or their intellectual property. So you generally will have a clause that will extend not just while you're at the employer, but even beyond termination in the end, no matter the reason that you're terminated. Or it may have like a 2-year period of time or something like that after the termination of employment, that you have to keep those things confidential. Let's see. Okay, next slide. So sometimes employment agreements will have a clause on evaluations, and Joyce and I were talking earlier. She feels very favorable towards having an evaluation clause in it, in an employment agreement, because it requires the employer to give you an evaluation, periodically, give you feedback. And for instance, if you have a for-cause employment agreement, it could cue you into the fact that your supervisor thinks that you're doing something wrong, and it's something that you can go ahead and try to fix before the employer can say that you're being terminated with cause. It may say how often you're going to get an evaluation. It may say the metrics that you're going to be evaluated on. And relating to one of the earlier slides, bonuses, your bonus may be tied to your evaluation. So if you have a requirement on the supervisor to give an evaluation, that may, it may delay your bonus, for instance, if they haven't given you an evaluation yet. because that's just how the employer pays bonuses. So there's a lot of reasons why you might want to ask for an evaluations clause. Next slide. So similar to the trade secrets clause, there may be a clause that includes the terms for who owns your work. And when you work for a particular company, especially in the engineering field, and you are, developing an invention, or I think it's also in some, professors' agreements, talking about curriculum that they've created while they're employed by the university. So there's a lot of different things that intellectual property or patents and things that can belong to the employee, or it could belong to the employer, and the employment agreement may liberally cover a lot of inventions and things that you may not be expecting. So whenever you leave, the employer might claim that they own that invention or they own that patent. So if you come into a employment agreement where there's an ownership, a work product clause, you want to make sure that you've carved anything out or listed, a particular product or invention that you already have or that you're working on, and go ahead and specify that in advance so there's no confusion whenever you leave about who owns your work.
Excuse me,
slide.
Lisa.
Sure.
Before we move on, there's a question from Alex. And he says, if you did not have a specified confidentiality agreement, how much information can you share about previous projects?
Okay, so if you, I'm just trying to understand the question.
Right.
So if you're moving to another
Don't have an
employer-
agreement, how much information can you
I can
share?
field this one, give you a break. If you don't have agreement, you're still covered by the Trade Secrets Act. And that really is anything that the employer is taking precautions to keep secret, right? They're keeping it password protected, locked in drawers. Having people sign confidentiality agreements is one of the ways you can prove it was quiet. Anything like that, you can't talk about it to third parties at all. And so if you're being asked, well, tell me about the project you worked on, right? You'd have to figure out, well, is the whole project, they're working on some sort of, cell phone app that if I even tell them what it is would violate, then you can't. But again, if you're in an industry that's dealing with that, you can simply say, I'm working on an application. It's a trade secret. I'm not allowed to disclose it, but I do have skill sets in ABC, right? And focus on the skill set, not on the product itself, is what I would recommend. Anything they're taking precautions to keep secret, you can't talk about.
Okay, so let's see.
Thanks, Joyce. Did that answer your question, Alex?
I think so. He said, thank you in the chat. So
There you go. Thank you both.
Okay, so the next, okay, so we can move on to the next slide, I think. Okay, so one of the most important clauses to look out for that you may not be expecting is a clause that discusses the methods of resolving a dispute that could arise based on the contract, so a breach of contract action. And sometimes, other disputes that happen during the employment. One common one that most people have seen at some point in their life is an arbitration agreement. And in some cases, employers will seek to have you agree to resolve any disputes via arbitration, which is a private process that for the employer, keeps things confidential. And that's going to mean that the remedy is decided by a private arbitration or arbitrator, who generally is going to be paid by the employer. So it can be very employer friendly. In arbitrations, the rules of evidence are not the same. And if you get a bad decision in the end that you disagree with, it's going to be really difficult to change that or, appeal that in any way. So it tends to lean in favor of the employer. Another cause might be a jury waiver. If you waive your right to have a jury decide your case, that's one similar way. You would have a bench trial instead. There may be a provision, if there is an arbitration clause, there may be a provision in there discussing how the arbitrator would be selected. And that's one of the areas where you could have some, you could negotiate a little bit. But there are certain things you can't have an arbitration clause for, such as in Maryland, and a few other states have changed this. You can't be prevented. There can be an arbitration clause in advance for sexual harassment cases. But generally, if there's a standard arbitration clause in there, you just want to make sure you're aware of what rights you're agreeing to waive if a dispute were to come up. Next slide. So a choice of law provision is usually sort of one of the last, 5 or 6 clauses. And it usually is going to, Joyce mentioned this earlier, it's going to say what state governs your rights and and governs the contract law that will apply to that particular contract. And like Joyce mentioned, if the contract said something like it'd be governed by the laws of California, that would be great for you as an employee. But if it were, for instance, governed by the laws of Georgia, which has very few employee protections, then it might not be so good for you. Usually what I've seen in Maryland, it usually says governed by the laws of Maryland. And it probably is like that in most states, where the attorney drafting the agreement just goes ahead and puts the state that they practice in. But a particular company, there was a question about headquarters earlier, they may, want the law of where their headquarters are to apply in that particular contract. So that's usually in almost every employment agreement, a choice of law provision. Next slide. So there may, and similar to the remedies we were discussing earlier, there may be a clause in there talking about, which basically says the employer can get an injunction to force, performance of the agreement. An injunction is where a court orders a person or an entity to do something. So for instance, if you had a non-compete and the former employer took you to court and said you're not allowed to work for this new employer, an injunction from the court would be saying you have to quit that job. So that can be important, and you definitely want to make sure that there's some sort of balance in a remedies clause discussing an injunction. There may also be an attorney's fees clause talking about who pays the attorney's fees. So that's a common clause that you'll see. Okay, next slide. So a notices clause, you'll pay attention to, you need to pay attention to the way that notice is required to be given. So notice may be by email or fax or paper mail, but usually it's in some written form. But it's important to pay attention to how notice should be delivered from both sides' perspective, because if there's a particular notice time period that starts upon delivery of notice to the other side, for instance, you're giving notice of leaving, If you have to give 30 days notice and you send it via fax, I mean, you send it by email, but it required you to send it by certified mail, you may not have started that 30-day period yet, 2 weeks into it, and the employer says, no, you have to work for me for another 30 days. So that's a provision to look out for too. Next slide. So there may be a clause in your agreement that says that represents that you don't have a non-compete that would apply to prevent you from working for the current employer. Joyce is going to talk more about non-competes, but for instance, if you had a non-compete agreement with your former employer that said you can't work in a similar business within 30 miles or something, and then you go to work for a new employer and they've given you an employment contract like this, and you think you have a non-compete that you don't think should apply, but your former employer might think could apply to the business you're applying with, you don't want the company to be caught off guard later that, when your former employer brings this lawsuit, because they could be bringing a lawsuit of interference of contract against the new employer. And, you could easily, that would be a breach of the agreement that you're making this representation that you don't have a non-compete and you haven't disclosed it. So it's good to go ahead and disclose it to the employer and let them know why you don't think the non-compete applies in this situation, or why it's unenforceable, or they spoke to an attorney and they don't think it's applicable in the situation. So it's important to look for, what you're representing whenever you sign the agreement. Next slide. There's usually in almost every contract a clause saying that this is the entire agreement and that no representations and warranties prior to this agreement or oral agreements prior to signing the current agreement are effective. So you frequently in a job situation, hiring situation, a new employer might have a conversation with your soon-to-be supervisor, and he or she is telling you, this is how bonuses are done. We typically do it this way, but the agreement says something very different. An entire agreement clause is going to prevent you from saying, wait a minute, they told me verbally during my interview that that bonuses were based on this metric, and even though the employment agreement says this, my supervisor told me they tend to, they give you a little bit more if you do really well. That if it's not in the agreement, then it's not going to apply if there's an entire agreement clause. Next slide. So most agreements between an employer and employee will have an independent legal advice advisement that oftentimes it's in bold or all caps saying that you've been told to seek independent legal advice. That's because the employer doesn't want you to come back later and say you were under duress or you were pressured, whenever you took the job, or you didn't understand a certain clause. And so it shouldn't apply. But it generally is a good idea anyway to get legal advice. A lot of the employment agreements that I see are after the fact, where if somebody's coming in because they're either being terminated or they want to leave, and they didn't seek legal advice when they first signed the agreement. So they don't even really know what certain clauses mean because they just didn't assume they were going to be in the situation, or, something came up and now they think they're going to be terminated for cause. So it's good to get independent legal advice because they're going to let you know, hey, you could negotiate this, or you should get clearer for cause terms because this situation could come up. So it's a good idea to go ahead and get that anyway, but there's usually going to be a clause in there stating that you've been given plenty of time to get legal advice. Next slide. A severability clause is another one that's usually down there with the choice of law clause. And it's going to say, basically, if there's a clause in here that's deemed void or invalid, it's not going to invalidate the entire agreement. That provision that is invalid can be severed, and the rest of it will be in full effect. So a severability clause is just basically preventing, you can't just find a clause that could be deemed void, like an arbitration clause for, sexual harassment claims, and then the rest of the agreement is void. It's going to allow the rest of the agreement to be in effect. Next slide. This is a really important one, even though it's a pretty simple one. There should be a clause in there stating that all amendments and modifications to the agreement are to be in writing and signed by both parties. You don't want the agreement to just be changed by one side, obviously, and you don't want one of them to claim that there was a change, orally in a conversation between two people and they both understood it differently. It should be in writing and signed by both parties. And you certainly want to make sure that those that it's stated clearly how the agreement can be changed, or when it could be changed, or even what provisions can be changed or can't be changed. So those are sort of the basic clauses that you often see in employment agreements. And I'll turn it over to Joyce to talk about non-competes and other things.
Next slide. So I know we're coming close on time, so I'm going to go through this pretty quickly. The materials are very detailed, and if you have any questions on any of it, feel free to email either one of us. We have a list here in this slide of the types of restrictive covenants you see, right? There's a non-compete, there's a non-solicit, right? Non-compete means even if the customers aren't the same, you just can't go to a competitor and work there. Non-solicit means you can't steal our customers. Non-solicit for employees, that's very common. You can't take our employees or solicit our employees for a year. So they come in different forms. This is a list. Next slide. Again, it varies from state to state, but these get scrutiny in almost all states. There's a strong belief that we all have a right to earn a livelihood, and the economy and people, benefit from having competition, very basis of antitrust law. Next slide. So these are the things that you're going to look at to decide if it's enforceable. If you are in a hot dog business, they can't prohibit you from going to a hamburger business. It has to be a protectable interest. So they can't just forbid you from doing something that, isn't even something they do. It has to be reasonable both in time. The most we usually see upheld is 2 years of a non-compete, and geography. And again, we'll see a couple counties, but if the wider they go with the net, the more likely it is to be struck down. I won a whole case on a doctor who had one because it was harmful to the public because he was the only surgeon in a particular area able to do certain oncological surgeries in all of DC. And so they struck it down. It also can't be unreasonably burdensome to you. If it means you can't work anymore, they're going to strike that down. Next slide. This right here is a list of examples of the kinds of things that would be protectable interests. You see confidential information again, that's very important in a lot of these areas. Courts are going to protect proprietary information, software, goodwill, things like that. Next slide. Non-solicitation of employees. The idea is you got access to these employees because you worked for us. We're not going to let you steal them. That would mean, contacting them. I had a case last year where somebody put something on their Facebook saying my company is hiring, and there were people from his old company on Facebook, and they started a legal action about it. So just be mindful of what you're signing there. Obviously also there's going to be concern that you might take property with you to another employer. And of course, your employer gets dragged into this, the new one, because they are tortiously interfering with the contract of non-compete. So a lot to look at there. Next slide. I mentioned the reasonableness. The geography has to be reasonable. The time limits have to be reasonable. No hard and fast rules is certainly true. You just have to dive into the case law. There's 50 to 75 cases just in Maryland interpreting these. But again, you know, a couple counties 10 miles from the business, we're seeing those upheld. We're seeing about 2 years. Next slide. Reasonable restrictions. These are really self-explanatory. You'll have the materials available to you. These are examples from real cases that have been upheld. So you can look through these and get an idea. Oh, 2 years here, 2 years there. Next slide. These were found to be unreasonable. Good examples here, 5 years being held not valid, 2 years in Baltimore City wasn't upheld because of the type of business it was. That was too long. Lots of examples here. I'll move to the next slide. And this is a good example. I really like this slide. This one is one to star. If they're specifying prospective customers, how in the world do you know who those people are? I don't know, somebody over here has been talking to someone and I'm supposed to know I can't work for them. Watch out for that one. We see that a lot. Also, whether you left to start a competing business or they fired you, these employers who take the position of you're too bad to work for me, but you're so good, you can't work for anyone else without harming us. That is considered in these cases. Whether or not there was good faith on both sides, that implied covenant of good faith. Trade secrets, presence of straight trade secrets, courts are going to protect those. That is something courts view as very sacred. And how much the business invested in you, right? If they put a huge marketing campaign out there that you are going to oversee a division and then you want to compete, that's going to be something the court will consider. Next slide. Here's some examples again, right from cases that were knocked down for being burdensome to the employee. You've got samples there in the materials. Next slide. This one, consideration. For a valid contract, both parties have to give something up. That's just basic contract law. You can't, if not, it's a gift and it's not a contract. Most of the jurisdictions will say, including Maryland, that continued employment is valid reason to uphold one of these, that's enough for them to give, saying you won't have a job with us if you don't sign it. Courts will uphold that, even though it feels like duress, right? A lot of people say, well, it was duress. I was going to lose my job if I didn't. Courts have specifically held being forced to sign a non-compete is not duress. So you're going to lose that argument if you make it. So just be aware, if you sign it, it's going to be really hard to get out of it. The courts do not like the duress arguments. Next slide. Blue penciling, judges have the ability and right to take their judicial pencil and take an overly broad non-compete and cross it out and narrow it down and make it more reasonable. So if there's a 5-year one, a judge, instead of throwing it out, can turn it into 2 years. So just because you get handed an unreasonable one doesn't mean you get to throw it out the window. So keep that in mind. If you think, oh, I don't have to worry about this at all. No, I remember Joyce saying 5 years is too much. The judge can come in and change that with their judicial pencil. Next slide. So, what happens if you breach, I leave early? We see people coming back saying, pay back the moving costs or pay back a bonus, things like that. That's what we usually see. So if you get a big moving expense of $30K, which I see out there sometimes, and then you breach your contract, they're probably going to come after you for that. Next slide. Keep a signed copy. Yes, I can't tell you how many people come to me and say, I signed something. I have no idea. I put it somewhere 5 years ago and I can't help them because I have no idea. And then we have to call the other side, which is a very impressive way to start your representation, saying, we have no idea what the contract says. We're sure we're right, but can you send it to us, please? So keep a signed copy. I think that's probably the last slide. When to get a lawyer. We are lawyers. I think it's penny wise, pound foolish to wait too long. You can get ahead of so many issues if you just are smart ahead of time. People who tend to spend a couple $100 getting a lawyer to review and negotiate their contract are the ones who don't come back to me for several tens of thousands of dollars of defense work on a non-compete. It's good to get them involved. Next slide. That's it. 2 minutes over, I apologize for that. But I'm happy to take questions for those who want to stay and do that if that's okay with everyone here. And if not, please feel free to email either Lisa or me. My address appears right in this last slide. I saw them putting in the comments that you'll have this slide presentation. So absolutely feel free to reach out to either one of us. If there are questions you have, happy to answer them.
Joyce and Lisa, we have two questions. One is from Aria, and she says, is the immigration sponsorship included in the contract? And then the second question, also from Aria, is if I'm going to sign a contract with a big giant tech company, does that mean I can do little to change the contract and can only sign or quit?
Yeah, both good questions. What they're doing to sponsor your visas is almost always laid out in the contract. You can be in a vulnerable position if your employer also holds your right to be in the country. We deal with this all the time where somebody will call and say, whoa, they're invoking termination for cause and I'm going to have to leave the country if I lose this job. It's really good to get those protections up front, make sure you've got notice and what they're going to do to sponsor that visa. Absolutely. We see those in contracts. That's normal. And if you're in that situation, definitely call a lawyer to make sure you've got some notice provisions and protection, because if you don't, you can lose everything on one phone call, which is terrible. On the second question, how negotiable is all this if you're up against a big company? Some of that depends on leverage, right? A lot of the big companies don't want the word to get out there that it's negotiable because everybody talks and now all of a sudden they're negotiating a bunch of contracts and everyone's is different and no one's happy about that. But the higher up you go, when I do CEO type contracts, obviously I've got lots of leverage. They want the specific person. And, we negotiate a lot of them. We have a fair amount of success. There's a labor shortage in most markets right now. And if you're not willing to negotiate these, people are going to the next person who will. So my experience is a lot of them will negotiate, even if you're entry level, even if it's a big company, as long as you're not altering something that's really important to them. They recognize, right, that they're going to lose good candidates if they refuse to talk to you about your needs in the contract.
And then kind of on that note, Andrew asked, I'm hoping to hear about renegotiating salaries and when that proposal is taken by the company as declining the offer. I guess the company has made an offer and you try to renegotiate something higher and the company says, oh, well, forget it. You decline the offer.
Ooh, okay. Most companies don't do that. I have heard of that happening though. Offers just go by basic contract law, right? There's an offer, there's an acceptance, a meeting of the minds, that's a contract. So if there's an offer and instead of an acceptance, you come back and say a counter, that technically is a rejection. Does that happen most of the time that they say, never mind? I've seen it happen, but it's rare. I mean, I would say less than 5% of the time. And in fact, there are laws getting passed to try to make it easier for employees to negotiate. You're not allowed to ask anymore what their last salary was. So it's unusual for them to pull it. I think they expect you to negotiate. I mean, frankly, I hire lawyers, and if they just, take my first offer, I scratch my head and wonder what's going on. So, do your research is what I will say, control your messaging there. I think it's a good idea to go back and say, look, I am very interested in this, but I would like to talk, right? Don't just say I reject and here's what I want, but go back and say, this is a great opportunity. I like the type of work I'm doing. I really like the person who's going to supervise my work. So much to learn, but I did this research, right? Here's what I found here's the average starting salary for this thing. Here's this, here's that. I like you guys, but can we meet what's happening in the market? If you approach it that way, instead of just saying, but I want more money, my rent's higher, right? Like that doesn't, I hear people use that. Your rent is not the employer's concern, but the market is, right? They don't want to keep losing people. So do your research. Most employers expect you to negotiate. And if you have your research and express all the positive things about the company, I think it's very unlikely they'll pull it, for you having come in and done your research and asking for market pay.
I think you just answered this, Joyce, but Andrew followed up with, so do you think it's always smart to renegotiate if you have a higher paying offer?
You have to do it carefully, right? Because once there's a higher paying offer, they may think, oh, they're just going to chase the check, not the right organization, right? Like if you're like, I can't imagine telling an Elon Musk type personality, someone else wants to pay me more. Well, someone else, isn't going to Mars like he is. And I think he'd probably kick you out if you're dealing with one of those personalities. So you got to be careful. If that's the opportunity you really want, but it's paying less, I think, again, you do the research and you can come in and say, look, this is the one I want. And I have this other offer, but this is what I want, right? It takes away a little bit of your leverage, but it also doesn't bruise the egos or make people think you're just chasing the money and don't really care about the important work they're doing. Every company owner likes to think what they do is important. And if they feel like you're just chasing the biggest dollar, that can be a turnoff. So just go in again, expressing positive things about the company, but show your research. You're not just asking for no reason. Someone else has an offer on the table, but I like you. Can you match it? That's how I would handle that.
Okay. Veronica just put a message in the chat. Want to make sure that everybody saw that if you're an engineering student, please attend their evaluation, job offers, and salary negotiation workshop. They do that with the Engineering Career Services Office, and you can find it on Careers for Engineers.
All right. Do you have anything else to add, Veronica? Okay.
No, thank you so much for having this presentation. It's very helpful.
Yeah, well, thank you for the follow-up. That's awesome. All right. Well, thank you, Joyce and Lisa. Not only did you stay over and answer all the questions, you just helped us understand the language of contracts and how students can protect themselves. So I hope it was worth your time. It was certainly worth my time and our students' time. So thank you to everyone who is watching it live and those who are going to watch the recording. If you have a job contract and you would like one of our attorneys to look at it, we've got Cindy and Zach on staff who will take a look at it. And if they have questions, they may call Joyce or Lisa. So we will all work together to, make sure that you are protected. So everyone,
Thank
I'm
you.
sending you. Go ahead, Cindy. I'm sorry.
I just wanted to add, thank you so much. And Zach and I do those initial reviews, and we know that if it goes beyond what we can do, or you need assistance that is on a different scale, then we will certainly refer you to Joyce and Lisa in the private sector. So yeah, feel free to reach out to any of us.
Okay, sounds good. And thank you, Cindy, for helping with the questions. Everyone, take a minute to fill out that survey so we can make sure we're doing a good job. We've got 2 workshops coming up. One is this Friday. It's a special workshop that we just recently added. So it's on Friday, March 4th. Our immigration attorney, Patricia Minicon, will discuss the new and happily favorable rules for national interest waivers. So this is important information for international students, especially those who are in the STEM field. So, and then next Tuesday, back onto our regular schedule for our GRadulting workshops, March 8th, we will be with the staff from ISSS, and they are going to discuss life after F1 J1. So I hope to see you soon. Have a good week, everyone, and let us know at Legal Aid how we can help you. Bye-bye.